not just posting, but promoting bad information.
Understanding their news from
What's going on, everybody? Right now, we're streaming oral arguments from the Supreme Court of the United States.
federal government doing that to them. But maybe
What
I'm
are
right.
they
Maybe
arguing?
that goes on
It's
behind the
today
scenes.
is
it
Surgeon
struck me as,
General
wow, this is not what I
Murthy
understand
versus
the
Missouri,
relationship.
Missouri,
That's all I
and NRA versus
I
Vulo.
think this is important because I have the
we're
same
listening
reaction that you do,
about,
that these emails look unusual. I think the idea that there'd be back and forth between the government and the media isn't unusual
and the
at all.
media
When the
and
White House
their
press
unholy
secretary on
relationship.
July 16th is asked about this by the press at the time, what she says is, of course we talk to the platforms just the way we talk to all of you when we have concerns about what you're doing, when we have information that you might find helpful. Now, there's an intensity of the back and forth here.
And Supreme Court doesn't stream live like a video, it's just audio, so that's why.
We think we have a responsibility to give people accurate information and not bad information, and we're doing everything we can to meet that goal. That's where this language of partnership comes from. It's not just from the White House, it's these platforms, which are powerful, sophisticated entities, saying we're doing the best we can. And the anger, I think really most of the anger when you read the emails, and I appreciate that you have, because I think you have to look at them in context, the anger is when the officials think that the platforms are not being transparent about the scope of the problem or aren't giving the information that's available.
Well, let me ask you one more question, and then I'll stop, at least for now. You make a big point in both your brief and your reply that states don't have First Amendment rights. But are you saying that they may have a free speech right, but it comes from someplace else, or they don't have free speech rights? Do you think that the federal government could prohibit a governor or the top-ranking public health official in a state from speaking to the residents?
No, I don't think it could, and I want to be clear. We're not denying that they have speech rights. We're saying that those things, like the federal government's speech rights, come from the structure of our Constitution, not from the First Amendment. This is a First Amendment case, and I think really what's happening here is that these states, which were the motivating factor behind the suit, the only plaintiffs in the initial complaint, are really trying to represent and to litigate the First Amendment rights of their citizens on their citizens' behalf. We think that's an end run around the limit on parents patriae standing, just like the one the court rejected.
Do you think, on the anger point, I guess I'd assumed, experienced government press people throughout the federal government who regularly call up.
In case you're wondering, this is about the First Amendment and the government's unholy alliance with the media during COVID.
Is that not?
How they restricted First Amendments.
You said
the
the
First
anger
Amendment
here was unusual. I guess I wasn't entirely clear on that from my own experience.
That's fair. I guess I don't want to endorse berate, but I guess I will say I bet this is not the first time that there's been profanity or intemperate language in exchanges between White House or agency communication staff and members of the press.
Well, I don't know whether our public information officer is here today, but maybe she should take a note about this. So whenever they write something that we don't like, she can call them up and curse them out and say, why don't we be partners? We're on the same team. Why don't you show us what you're going to write beforehand? We'll edit it for you, make sure it's accurate.
So, Justice Alito, this is why I want to be careful here. I'm acknowledging the reality that this happens and that it may be commonplace. I'm not saying it's a good thing or a great thing or a thing to be celebrated, but fundamentally I'm saying the First Amendment isn't a civility code. It is an important protection. It's a critical protection against actual coercion, but I think it's important to police that line, and I think this case, the sort of sprawling audit of all of these communications, shows the danger of allowing parties, especially parties without real direct injuries, to come into court and to challenge these sorts of regular back and forths. Here it's an open.
We're going to try this again. So I started streaming horizontally first, and then I switched over to vertical, but guess what? It's kind of stuck in the horizontal. We're good now, though. I'm checking, I'm looking.
That we're a source of information for people, and we want to be a
And
source
hey, it says we're still going for 4 minutes. Okay.
And says we have some concerns about this. They say we agree. That's a good point you make over here.
Breaking news: ABC just released the most devastating coverage of.
And Mr. Fletcher, whether or not that ultimately becomes a First Amendment violation, I mean, I appreciate the coercion point, and that's sort of the government's first point with respect to the merits of this. But I'm interested in your view that the context doesn't, quote, change the First Amendment principles. I mean, I understood our First Amendment jurisprudence to require heightened scrutiny of government restrictions of speech, but not necessarily a total prohibition when you're talking about a compelling interest of the government to ensure, for example, that the public has accurate information in the context of a once-in-a-lifetime pandemic. So I'm just interested in the government sort of conceding that if there was coercion, then we automatically have a First Amendment violation.
So I'm not conceding that that would be the case. I could imagine that in times of pandemic, if there were actual restrictions, maybe those would be justified. But our position here, because we think it's the position consistent with the facts, is that there wasn't any coercion to begin with.
Mr. Fletcher, on that point, you mentioned
They
coercion.
think that there wasn't any coercion to begin
communicated
with. Don't worry,
in terms of
guys.
threats. Can there also be coercion, in your view, in terms of inducements?
We think there can. I think often a threat or an inducement is sort of the flip side, one or the other. I think in the next case you could construe it either way, threat of prosecution, offer of leniency. So we acknowledge that it can be both, but it has to be a threat or an inducement of some.
Oh no. I definitely just accidentally turned off the audio. Here we go. We're back.
As coercion?
Sure.
And a threat or an inducement with respect to Section 230 qualify?
So I think that one's harder for two reasons. One is that these are executive branch officials who don't have the ability to unilaterally enact 230 reform. I think the question is...
But they have a power to influence that.
Influence that, but the question is...
Would that be enough to say we're going to, if you don't do X, we are going to change our position on Section 230?
So potentially yes as to legislation. 230, if I could just get this out though, I think is different because 230 is about content moderation. It's about this very issue, and I think a government official has to be able to say, I support Section 230 reform because I'm concerned about these things, and also in the meantime, I think platforms should be doing better.
I understand that, but in terms of advocating for change of Section 230,
The government thinks the private businesses should be doing
If it
better.
were framed as a threat, our position is that wasn't done here.
And how about...
The private sector thinks the same thing about the government.
Could that be
Unreal.
coercion in some circumstances? That if you don't change your moderation policies, you're responsible for killing people?
So I think that one is much harder. That's a statement that President Biden made off the cuff to the
I'm not.
press.
Listen. I'm not talking about the context, specific issues, and I understand you have arguments there. But could that, in some circumstances, an accusation by a government official that unless you change your policies, you're responsible for killing people, could that be coercion?
So I find it hard to imagine a situation where that sort of public statement could be. I'll acknowledge, as you say, context matters a ton, and so I don't want to say it's impossible. All I'm saying is it didn't happen here. The president said this to the public in the middle of a pandemic, and then 3 days later, I think this is important, he clarified. He said, I'm not saying Facebook is killing people. I'm saying the people spreading misinformation are. And when he was asked, will you hold the platforms accountable? He was explicitly asked this. Will you hold them accountable if they don't do better? He said, I'm not looking to hold anyone accountable. I just want everyone to look in their mirror and imagine what would happen if this misinformation was going to their loved ones. I think it's clear that this was exhortation, not threat.
Thank you, Mr. Fletcher. How are we supposed to evaluate that question and what the level at which coercion kicks in? I mean, if you're trying to coerce or get...
According to the government, it's only gun to the head. That's when it kicks in. That's it.
You know, if you don't do this, we're going to move your reporter's cubicle down
Next
the
up's
hall.
going to be NRA versus Bulo.
How do you evaluate when it constitutes coercion?
It's another
in this
First Amendment case,
So
actually.
let me start with, I think Bantam Books has been the lodestar for the lower courts that have mostly coalesced with some errors in application like this case around the idea of the question is it a threat or a statement that a reasonable person would understand, viewed objectively and in context, as an implicit or explicit threat of some adverse government action? Now, as to the cubicles question, I sort of don't know if there are some adverse government actions that are so
sounds like the
trivial
government's
that they don't
losing this
count.
one.
I guess I think something like that seems less likely
Based on
to
the
be
questions
a
being
coercive
asked by
threat.
the justices.
But in general, I
Which
think
is
our
good,
position is,
because
if there's something
they
that the government's
absolutely
saying, we're
coerce
going to
social media
exercise government
platforms, and
power
even,
in some way,
you know,
unless you
I
change
think
your
they may
speech in
have
some way or
entangled
stop
themselves
distributing
with
the
them.
speech of others. If it's reasonably understood as that sort of a threat, that's a First Amendment problem.
Well, but under Bantam Books, it presumably is in context what you're talking about a reasonable person. I mean, if there is, as a regular basis, the kind of back and forth between a spokesman and a member of the media, what a reasonable person might view as coercive might not, in that context, you know, maybe the press secretary yells on a regular basis, and if their, volume increases enough, that might be viewed as coercion.
So Bantam
I think that
Books
points out the
versus Sullivan is a
context sensitivity,
1963
and I think
case
as is usually the
involving
case when
government
the court says it's a
communications with
reasonable
book
person test, it's a
publishers about
reasonable person with knowledge of
objectionable
all the facts,
books.
and I think that would
You know,
include
similar,
the course of dealing
similar to
with
what we
the
saw with
government
COVID,
official
right?
and
The court
the
found that the
recipient.
government's
I think
cooperation
here that would
requests,
strongly
which
reinforce
hinted
the
at
idea that
potential
there wasn't
prosecution,
coercion. These
were a form of
sophisticated
censorship
parties
not voluntary
routinely said no
cooperation.
to the government. They were open about it. They didn't hesitate to do it.
It's relevant to
And
this
when they
case
said
because
no
it
to the
establishes a
government,
line where the
never
government
made any
actions
sort
can be
of
seen as
retaliation.
coercive and
Instead,
thus a
it
form of
engaged in more
censorship that
speech.
infringes
Ultimately,
on
the president
First
and the
Amendment
Secretary, the
rights.
Surgeon General took to the bully pulpit. We just don't think that's coercive.
Thank you. Justice Thomas?
Mr. Fletcher, back to my point about coercion. Couldn't you simply censor someone or prevent other speech by others by agreeing with the platforms as opposed to coercing the platforms?
I guess I'm not sure what you mean by agreeing with the
Well, you
platforms.
just work together, said, look, we're right, they're wrong. Let's work together. You know, we're on the same team. Let's work together to make sure that this misinformation doesn't gain sort of any following.
So I think as long as the platforms are exercising their own independent judgment, that's what the First Amendment protects. It says we don't want the government messing
So
with...
you're saying that the government can't censor by coordinating with private parties to exclude other speech?
I'm saying that when the government persuades a
ban
private
books.
party not to distribute or promote someone else's speech, that's not censorship. That's persuading a private party to do something that they're lawfully entitled to do. And there are lots of contexts where government officials can persuade private parties to do things that the officials couldn't do
The
directly.
next case we're going to listen to,
So, for
NRA versus
example,
Wulu, is about that too.
recently after the October 7th
government
attacks
had
in
the
Israel,
NRA
a number of
debanked
public
in New
officials
York.
called on colleges and universities to do more about anti-Semitic hate speech on campus. I'm not sure, and I doubt that the government could mandate those sorts of changes in enforcement or policy, but public officials can call for those changes. The government can encourage parents to monitor their children's cell phone usage, or internet companies to watch out for child pornography on their platforms, even if the Fourth Amendment would prevent the government from doing that directly.
Guys
All of those are
dropping the big
contexts where
P
the government
word.
can persuade
It's
a
gonna
private
be
party to do
deranking my
something that
stream.
private parties lawfully
Watch your
entitled to
language,
do.
sir.
And we think that's what the government is doing when it's saying to these platforms, your platforms and your algorithms and the way that you're presenting information is causing harm, and we think you should stop, and the platforms are
So
persuading.
you really don't see any difference?
You're causing
between
harm. Can you imagine the people from the
government
Biden administration
coordinating
in a room
with,
having this meeting?
the platforms to exclude other speech and persuading the platforms to do this, to not engage or permit other speech?
I guess I'm not seeing it, and I think that what happened here was definitely on the, if you do think there's a difference between those two things, I guess my argument here would be that what happened is on the persuasion side of the line, because you do see that back and forth of the platforms throughout the process saying no repeatedly when they disagree with what the government is asking them to do. And I think that that tells you that what was happening here is what the First Amendment protects, which is private speakers making independent judgment, informed by, maybe even influenced by the government.
So
but
there's
deciding
no
what's-
difference between the platforms meeting and working out an arrangement not to permit certain speech, and the platforms working with the government to do the exact same thing. There's no difference.
Well, I think if the platforms entered into some agreement amongst themselves, that might raise issues under different provisions of law. The modest point I'm making is just that the government doesn't violate the First Amendment when it persuades a speaker to not distribute speech by
If you haven't
someone
already,
else.
guys,
That's Penthouse
subscribe.
versus
I don't
Meese,
know
Judge
about you.
Silverman's
I don't like
opinion
getting my
there.
news
That's what
from
happens when the White House
journalists.
press secretary calls up the New York
I like
Times
to get
and
it
says that was a
directly from
bad
the
op-ed.
source.
You shouldn't run op-eds like that anymore. I think that's commonplace.
Justice Alito?
On the traceability causation question,
Alito.
under Murthy, if the plaintiffs show that the government's actions were a motivating factor, it is not their obligation, isn't this true, to show that they would not, that the platforms would not have done what they did were it not for what the government did? It would be the defendant's obligation to show that.
So I confess, Justice Alito, I'm not sure that the court has ever gotten through whether that burden shifting inquiry applies in the context of traceability as opposed to in a Mount Healthy merits type inquiry. I guess what I'd say is the court has been pretty emphatic that when your injury is attributable to independent choices by private actors, that's not traceable, and our submission is that that's what happened
Well,
here.
wouldn't it be
Do
very
me a favor
strange
and
to have
subscribe
a
if you want to
stricter
get
standard on
news
the
right from the
merits and
source.
less defendant-friendly standard on the merits than at the standing
Helps
stage.
my channel. Growth to 1,000 this week,
One last
guys.
question, really quickly. You've never argued that this case is moot.
We have not, no.
Thank you.
Justice Sotomayor?
Counsel, you don't do a lot with Clapper, and it seems that Clapper really does change all of the cases in terms of requiring a heightened traceability standard, does it not?
So I think Clapper is very instructive here. We do cite and rely on it. We think it's relevant at traceability. We think it's perhaps most relevant at the sort of the future injury question, because I think we're right about traceability of all of the past moderation of their content that they talk about. But I think we're on even stronger ground in saying that the vast majority of the things they're talking about are about COVID-19
Justice
or unusual
Sotomayor,
idiosyncratic
right here.
stories from the 2020 election, and their burden is to show that they face an imminent threat. That's from Lyons, that's from O'Shea, that the injury is going to recur. That's Clapper too, and what Clapper also says, and this is instructive, is that to the extent they're censoring themselves, which is what they say, in the absence of such an imminent threat of actual government-caused harm, that's not enough for our
Can you go back to Ms. Hines' 90-day suspension? I'm not sure if this record is enormous, but do we know exactly what was censored for that 90 days?
So that's the problem. I don't think we do, or if we do...
I was looking for it and couldn't find it.
And when I would go through the red brief, pages 19 to 21, and connect up the dots here, one of the things that's hard is that there's not a lot of specifics about even the dates on when things happen. I guess I will say when the dates are provided, though, they don't line up. The very first
For those of you just joining, this is about the government censoring social media platforms or insisting that they censor their users over COVID-related content.
That's an indication that my harms
It's a free speech case, really, government coercion case, and NRA versus Hulu is the next oral argument we'd be listening to today, and that is similarly the government had the NRA debanked in the state of New York, basically threatening the banks and insurers, if you don't drop the NRA, we will, flex our government muscle and make it uncomfortable for you.
Thank you.
Justice Kagan?
This
On the
administration.
coercion question, is there anything that we have to review on clear error, or is it all legal?
I'd give you the same answer I gave before. I think historical fact, this statement was made, it was not made. If there were specific factual findings beyond that,
Justice
again,
Kagan,
historical facts,
right
we
here.
acknowledge their clear error. But things like this was pressure, this was coercion, we think those are characterizations. And then the ultimate standard, the ultimate First Amendment standard of was viewed objectively and in context, this communicating a threat. We think that's either law or maybe more probably law to facts that gets de novo review the way it usually does in the constitutional realm.
And on the past harm, future harm question that you were just talking about, I take it if no future harm...
De novo review occurs when a
that's
court decides
independently
an issue
sufficient,
without
right?
reference to the previous
And
court's
would there
decision,
be,
so
any,
Supreme Court doesn't care about the
difficulties
district
with
trial
confining
appeals court's
a
decisions.
holding
It's going to make its own
to
decision.
that if we were to find for you?
I don't think so at all. I think in some ways that's the narrowest, easiest way to resolve this case, is to say this is an action for injunctive relief. They have to show that they faced an imminent threat of future harm. We don't have to adjudicate the parties' disputes about the past harm. We just have to show that they haven't met that burden.
Thank you.
Justice Gorsuch?
On that question, in your view, when is the time that we should be considering that? Probably not today, it seems, right? It would be at the time that the court, in the first instance, issued the PI. Is that your view?
So I think it might be even earlier than that, just to be candid.
the complaint?
That might be the complaint. So the complaint for the states is, I think, May of 2022. The individuals get added in August of 2022. The place where I think I know for sure that the PI matters, though, is whether they've shown a likelihood of irreparable harm, which above and
Chat,
beyond
let me know.
standing is a requisite for injunctive
I lost
relief.
track.
I think that has to be
That is
shown
at the PI
at the
time.
PI, exactly.
Okay, so that's the relevant
Sounds like
date.
Roberts,
Okay.
maybe.
And then, when we're looking at coercion, is it in your mind a relevant consideration
Guess.
that the industry is very
could be Gorsuch.
concentrated, and that therefore coordination problems that otherwise might be difficult with the media, which are very diverse, might not
Here,
be
let's do this.
present in some cases?
So again, context matters, and I think in some ways the fact that these are very large, very powerful corporations cuts against a finding of coercion because they are very sophisticated. They didn't have any problem. They weren't shy about saying no to the government. I hesitate to say, though, that it suggests that you should change the First Amendment standards. I think the Knight brief is...
I'm not suggesting that. The Knight brief does discuss this and says it might be a relevant factor that there's such a concentration that it makes coordination between government entities and private entities easier.
It's no good.
Do you disagree with
Guys, if you haven't already,
I'm not
please
sure whether or
subscribe.
not I agree with that,
Journey
but
to
I think
1,000 by
point
the end of the
is that
month.
For our purposes, the constitutional line is between coercion and not coercion.
No, I understand that.
And so the
But
question...
it's a context-specific inquiries we've discussed.
Right.
You pointed out one way in which concentration might make it less susceptible to coercion. Do we have to account for the possibility as well that in some circumstances, and I'm not again, not case-specific, it may make coercion easier.
So if that were true, you would have to account for it. The reason I'm resisting is because I think the concerns about concentration in the industry go more to the potential effects of coercion if it happened than about whether or not coercion happened at all. I get that. I'm sensitive to that. And the point that I was trying to draw from the Knight brief was the First Amendment isn't the answer to problems of concentration in this industry.
I take that point. Thank you.
Justice Kavanaugh?
Just so I understand, your key legal argument is, I think, but correct me if I'm wrong, that coercion does not encompass significant encouragement or entanglement, and that it would be a mistake to so conclude because traditional everyday communications would suddenly be deemed problematic.
Exactly right. And really that what the lower courts have done here, I think, is to go beyond the coercion test and sort of to openly say, we're going to open up this state action encouragement door. And that, I think, risks turning the platforms and lots of other entities that are interacting with the government into state actors and restricting their editorial choices under the First Amendment.
By coercion, you mean threat of legal consequences, or do you
adverse government action.
Adverse government action, okay. Then on the killing people, hypothetical or not hypothetical,
from Missouri
statement. I mean, that raises kind of national security analogies. I don't know what your experience is if you've looked into this, but it's probably not uncommon for government officials to protest an upcoming story on surveillance or detention policy and say, you know, if you run that, it's going to harm the war effort and put Americans at, risk.
I can't profess to have had personal experience with that. I know it has happened. The Knight brief talks about some examples, and I think that's an example of a valuable sort of interchange as long as it stays on the persuasion side of the line. I think newspapers want to know if they're publishing a story might put lives at risk, and they don't have to listen to the government, but that's information that they can consider in exercising their editorial judgment.
If they tack on to that, and if you publish the story, we're going to pursue antitrust action against you.
Huge problem, yeah.
Right, okay. And then you haven't really described what you think the common interactions are. I mean, what do you think those are?
At issue in the complaint or
No, just
forward?
in general,
Yeah.
You're speaking on behalf of the United States. Again, my experience is the United States in all its manifestations has regular communications with the media to talk about things they don't like or don't want to see, or complaining about factual inaccuracies. But be interested in what you want to describe about that.
Yeah, so I think that's absolutely right, and I won't profess to give you a comprehensive overview. We've looked at this very carefully in the context of these defendants because we've a couple times been under the shadow of this injunction, and so we wanted to understand exactly what would be at stake there. And so I think it comes into a couple of different buckets. One of them is engagement on matters of public policy, and I think that's what was going on here. I think childhood mental health, anti-Semitic speech, Islamophobic speech online are in that category. Those are issues where the White House, the Surgeon General, others might want to make their views known, to use the bully pulpit, to call on the platforms to do more. Another is the national security space. I think the record is clearest there on the FBI providing these foreign malign influence selectors to the platforms for the platforms to take action if appropriate, or briefing them on foreign threats or about terrorist activity happening on the platforms. There's also a domestic law enforcement side of things, child exploitation, other things like that.
I mean, it'd be great if they actually were worried about that stuff, but they're really just worried about misinformation and COVID.
There's also election integrity issues, false statements about the times, places, or manners of elections, saying the polls have closed early, don't bother coming to vote in an effort to suppress people's vote, or Democrats vote on Wednesday, Republicans vote on Tuesday. Those sorts of schemes are of concern to the law enforcement entities.
Government's so slimy.
And then I think there's also the CDC's interactions, which involve providing advice.
This government,
by the way, we're seeing a lot of this information circulating on your platform. It's not true, or it's misleading about something that we've put out, or even just answering the platform's questions. I think one of the flavors you get from the amicus briefs on our side of the case is there are a lot of valuable ways where the government has information or expertise that it can offer to private speakers, and it would be a shame to chill that.
Thank you.
Justice Barrett?
So this might be a question about the distinction or the interplay between bantam books and just state action more generally. In Justice Thomas's questioning of you towards the end, he was talking about the distinction between encouragement and coercion. So what if Facebook said, and this is counterfactual, it's not what happened in this case, but what if Facebook said, you know what, We're partners, we're on the same team, this is a once-in-a-lifetime pandemic, and we think it would be most efficient and most helpful for the public good for us to just turn over our content moderation to you. That's not coercion, that's voluntary on Facebook's part, but wouldn't it be state action then?
So to me, it starts to veer over, and obviously with all the caveats, state action is incredibly context specific. I don't want to be definitive, but to me that starts to verge more over into the joint action. We're doing something together. The government is doing things. It's actually making decisions. It's not just advising or persuading the platforms. I think the rubric, that may well be state action, but the rubric would be, I think, more sound in the joint action cases than under significant encouragement, which has never been just us trying to persuade you to do something.
How do we consider the relationship between those two things? Because I agree with you, Bantam Books is about coercion and drawing the line there, but clearly there are some times when things veer into the joint action space where we would say that maybe there is state action, and there's a dispute in this case, it kind of comes up in the next one too, about which framework is the right one. What
Next one
advice do you
being
have?
Gulo.
Yeah,
NRA
so
versus
again,
Gulo.
I think if I were the court, I would want to be cautious about making too definitive pronouncements. I would say that here what's challenged is the persuasion, exhortation, bully pulpit, provision of advice, provision of information, and that when those things are at issue, the main yardstick is going to be Bantam Books. The main concern is going to be, have you crossed the line from just really trying to persuade to trying to threaten, and that Bantam is the right way to draw that line. I think there are a lot of different amicus briefs from a lot of different parties, like the Chamber and Net Choice. They all agree that's the right line in this context. I think you could reserve and say it'd be a very different question if you're talking about the government and the platforms acting together, turning over operational control, integrating their operations. That's a different case. It might present hard state action issues, but it's just really not the kind of issue here.
And not alleged here.
Exactly right,
Okay.
yeah.
My other question is about the findings of fact and clear error. So you were pretty insistent with Justice Kagan that we really, to address this standing point, don't have to review any of the district court's factual findings for clear error. And I just want to make sure that that's right, because I'm thinking about things you talked about with, I think it was Justice Alito, the interchange with the expletives, we're getting mad, we want answers now, are you whatever serious?
Yeah.
And that was actually
I'm gonna go
about,
close my office
Facebook
door.
now.
My
Or
kid
there was
opened
another
it.
change
Be right
that was
back.
exchange that was actually about somebody impersonating the president's granddaughter on Twitter. So if the lower courts, which I think they did, kind of conflated some of those threats with threats that were designed to be threats related to the
back.
pandemic and that kind of suppression, wouldn't that then be clear error, or do you think that's application of facts to law, or what?
So I apologize. I didn't mean to say that there's no clear error here at all. I just meant to say it would be findings of historical fact. And I think the ones that
And those count.
And those count. Those do get clear error review. But I think we pointed out places on the salient ones where they just are clearly erroneous. They're just demonstrably inaccurate in the two cases that you just identified. So there we might agree clear error applies, but to the extent that the lower courts were suggesting, and really more than
is
district court
making
than
the
Fifth Circuit,
argument
but a little bit the Fifth Circuit too, that
right
things
now?
were said.
Which
to
attorney,
speakers
solicitor
never
general,
said,
which
that the
person?
Secretary said words she never said. Our argument there would just be that those are clear error.
So in considering traceability, you would say that maybe there are some things that we would review for clear error because the erroneous, assuming that you're right, the erroneous conclusions about traceability depended partly on factual errors and then partly on applications of law to fact.
And an incorrect legal standard, yeah.
Thanks.
Justice Jackson?
So I guess I didn't perceive there to be such a sharp distinction between Blum and Bantam Books. The government seems to be arguing here that Bantam Books is the way to go, that Blum is not the right test, and I appreciate that Blum uses significant encouragement, but I think it says the question is whether the government, quote, has provided such significant encouragement, either overt or covert, that the choice must in law be deemed that of the state. That it's sort of suggesting, in the same way that Bantam Books is, that it's really about coercion as opposed to just encouragement. So am I wrong to think there's really not that much difference between the two?
So I don't think you're wrong there. I think we say that that's the way you ought to read the significant encouragement language, that it's positive incentives of government action that overwhelm the private party's choice and make it really the government's choice, not the private party's. You can just view that as the flip side of the sort of coercive threats from Bantam Books. I think the reason why you may have sensed me today and us in our briefs resisting Blum is because the lower courts and my friends on the other side have really tried to turn that significant.
This is Brian Ryan Fletcher.
To something quite different, into circumstances where the government encourages in some
Right,
colloquial sense
right
by
here.
urging, or persuading,
right there.
or, really strongly advocating something. And we just don't think that's what Blum means or what this court state action cases have ever said.
Okay, I understand that. And even if we have a world in which significant encouragement
dogs are going nuts
is
for some
referred,
reason.
is there something different to the government providing information?
Yes.
I mean, I'm a little worried about the respondents' what I think could be taken away from their view, which is that in situations in which the government has information that may be unique to the government's knowledge, but that it feels important for the public to have, that somehow becomes prohibited if, as a result of that information, these companies decide they're going to do something different with respect to content moderation.
That's our big concern, too, and that's exactly what the lower courts found crossed the line. The FBI providing information about covert foreign actors on platforms, the CDC providing information, or even answering questions about matters of public health. I think it'd be very troubling to say that those things are impermissible or create state action.
Thank you.
Thank you, counsel. Mr. Agingwaga?
Good morning, Mr. Chief Justice, and may it please the court. Government censorship has no place in our democracy. That is why this 20,000-page record is stunning. As the Fifth Circuit put it, the record reveals unrelenting pressure by the government to coerce social media platforms to suppress the speech of millions of Americans. The district court, which analyzed this record for a year, described it as arguably the most massive attack against free speech in American history, including the censorship of renowned scientists opining in their areas of expertise. And the government's levers of pressure are anathema to the First Amendment. Behind closed doors, the government badgers the platforms 24/7. It abuses them with profanity. It warns that the highest levels of the White House are concerned. It ominously says that the White House is considering its options. And it accuses platforms both of playing total Calvin ball and of hiding the ball, all to get the platforms to censor more speech. Under this onslaught, the platforms routinely cave. Now, last month in the net choice cases, the platforms told you that it's incredibly important that they create their own content moderation policies. But this record shows that they continually depart from those policies because of unrelenting government pressure.
This is who we're listening to right
Indeed,
now.
as Facebook recently disclosed in an internal email to former UK Deputy Prime Minister Nick Clegg, the reason Facebook did that was, quote, because we were under pressure by the administration. We shouldn't have done it. Now, my friend says all this is constitutional because the government has the right to persuade using the bully pulpit. But the government has no right to persuade platforms to violate
Benjamin
Americans'
Aganaga,
constitutional rights.
I believe.
And pressuring platforms in back rooms, shielded from public view, is not using the bully pulpit at all. That's just being a bully. I welcome the court's questions.
Counsel, I know your argument is basically a Bantam book argument, but do you need coercion in order to, do you think that's the only way you could make your
Sounds
case?
like that's
Or could
Justice Thomas.
coordination accomplish the same thing? That is, the government is censoring by joint actions with the platforms as opposed to coercing the platforms.
Your Honor, we don't need coercion as a theory. That's why we led with encouragement in our red brief. And I would point the court to what it said in Norwood, which is the court or the government cannot induce, encourage, and promote private actors to do directly what the government can't itself do directly. And that's, I think, the principle that's guiding here, which is regardless of the means that the government tries to use to pressure the platforms to commit censorship against third parties, the Constitution really doesn't care about that. It's the fact that what the government is trying to accomplish is the suppression of speech. And I would say, Your Honor, I mean, that's exactly how you address this question in Bantam Books. You asked, did the government set out to deliberately suppress speech? The answer in that case was absolutely yes, and that's absolutely the answer in this case here. And I guess, I would say, when this court considered Bantam Books, one of the key things about the analysis in Bantam Books was it was an obscenity case. And, the court struggled with whether the states had the right to police the line between legitimate speech and illegitimate speech.
For those
and
of you
that
just
was why
joining,
you were
this is
talking
about the
coercion in
government
that case.
restricting
You were
social
asking whether
media
the
sites,
I'm sorry. The reason
coercing
we were
them to
asking
restrict
about
COVID
coercion
content.
is because the private parties could have chosen on their own to censor that speech. They could have said, we think it's obscene, I'm not going to be involved in this. The only issue became when that choice was overwritten by the government. And so I think you're mixing sort of situations and confusing legal doctrines.
No, Your Honor, the fundamental principle, and this comes from Norwood, and it's central to this Court's First Amendment cases, this Fourth Amendment case, is that the government can't do indirectly what it's prohibited from doing directly. And that's what you see happening in Bantam Books. That's what you see happening in a case like this. Because time and again, there were times where the social media platforms had policies that didn't go far enough in censoring the speech that the government wanted them to censor.
But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate
All right, so not every situation in which the government engages in conduct that ultimately has some effect on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control...
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end, the government itself has undertaken action.
Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.
And could I just understand, because it seems like an extremely expansive argument, I must say, encouraging people basically to suppress their own speech. So, like Justice Kavanaugh, I've had some experience encouraging press to suppress their own speech. You just wrote a bad editorial. Here are the 5 reasons you shouldn't write another one. You just wrote a story that's filled with factual errors. Here are the 10 reasons why you shouldn't do that again. I mean, this happens literally thousands of times a day in the federal government.
Yeah, and I would say in the Minoran case that you're describing to me, it's the government going after the speaker itself and trying to get them to change their speech. What's so pernicious here is that you don't see any of these facts in this record unless we get discovery, which is when Rob Flaherty, who's Deputy Assistant to the President, sends an email to Facebook or to Twitter and complains that they're not doing enough to censor what they view as vaccine hesitancy speech. America never sees that, and the third party, people like Jill Hines and Jim Hoft, whose speech wishes to express the kinds of viewpoints that the White House is targeting, they never know that that's happening behind the scenes. And I think it makes a difference, Justice Kagan, that you have an intermediary here who really has no incentive to itself defend Jim Hoft's speech or to defend Jill Hines' speech. In the New York Times hypothetical, you have a storied publication that itself is familiar with those kinds of
op-eds? What about op-eds?
Your Honor, and with op-eds, if it's a third-party speech that
that happens too, right?
And I guess there are a number of ways I would think about that, Your Honor. One is if the newspaper declines to run an op-ed because the government asked, That op-ed author can go to any number of other publications and it has an outlet. It's not the same here, because if I'm on Twitter and I wish to express a viewpoint that the government wishes to censor and Twitter bows to that pressure, then I lose my account.
I was just going to say, first, I have no experience coercing anybody. But second, I mean, the government is not monolithic either. I suspect when there's pressure put on one of the platforms, or certainly one of the other media outlets, they have people they go to, probably in the government, to say, hey, they're trying to get me to do this, and that person may disagree with what the government's trying to do this. It's not monolithic, and that has to dilute the concept of coercion significantly, doesn't it?
Your Honor, I'm not sure I agree with that, and I guess I'd get back to one of the earlier points I made, which is, whether you call this coercion, if that's the label you attach, you call it encouragement, you call it promotion, you call it inducement. Whatever it is, if the government is attempting to abridge the speech rights of a third party, that has to be unconstitutional, because that falls within the plain text of the First Amendment. And so, this is Bantam Books of the 21st century. You haven't had a case with social media platforms like this where third-party speech is so at risk of being censored.
Well, but how do you analyze a situation where, maybe EPA is trying to coerce the platform about something, and the Army Corps of Engineers is trying to coerce them the other way? I mean, you can't just sort of pick and choose.
I hope I got the
part
right
of the
guy.
Government you're concerned about.
Right here.
And obviously, it's a different when you're talking about what the president is saying.
J. Benjamin
Other than that, I think
Aguinaga.
it's a very,
I think that's who they
more
called.
fluid situation than anything else.
It is fluid, Your Honor, but I would say that when you have, as we have plaintiffs in this case who wish to express certain viewpoints that have been specifically targeted by the government, it's not at least fluid in these facts. And this is not a case just about COVID. It's a case about election integrity. It's a case the district court has a finding about how the government
what
wishes
about
to...
that? I mean, take an example where, these platforms, they're compilers of speech. And some part of the government, let's call it part of the law enforcement arm of the government, says you might not realize it, but you are hosting a lot of terrorist speech, which is going to increase the chances that there's going to be some terrible harm that's going to take place. And we want to give you this information. We want to try to persuade you to take it down. The government can't do that?
The government can absolutely do that, Justice Kagan.
They're asking them to take down the speech.
Terrorist activity, criminal activity that is not protected speech. Absolutely, the government can inform
much it might be protected speech. I mean, terrorists engage in, things that come under the First Amendment. I mean, let's say they're just recruiting people for their organizations.
Your Honor, if it's First Amendment speech, protected speech, then I think we're in an entirely different world. I mean, that's a case where, and this comes up in the FBI findings that the district court made, because what was happening is the FBI was sending teleporter encrypted messages to the platforms identifying what the government represents was foreign actors. The district court found the government was not distinguishing between whether it was domestic or foreign conduct. And the way this issue arises is when maybe you have a foreign actor who tweets, I love Biden, and there are 20 million people who wish to retweet that, repost that with their own comments saying,
Not 20 million.
yeah, I love Biden too. When an American does
Less than
that's
10,000.
First Amendment protected speech, Your Honor. And so when the government comes in and tries to take down every single post that contains the core that they say was foreign speech, but they're also taking down the added speech by Americans, that's a square First Amendment issue, Your Honor.
So back in this still happens now. Decades ago, it happened all the time, which is somebody from the White House got in touch with somebody from the Washington Post and said this will just harm national security, and the Washington Post said, okay, whatever you say. I mean, that was all. That we didn't know enough, but that was coercion.
Your Honor, I thought I understood the government this morning to say that might be a First Amendment issue. And I think what I would say is if there's a national security interest, maybe the government can satisfy strict scrutiny in that circumstance. What I would also say is we probably wouldn't have a lawsuit based on that, because I don't know how that we would get prospective injunctive relief based on a fleeting, offhand, reach out from the White House.
I guess what I'm just trying to suggest is that there's all kinds of things that can appear on these platforms that do all kinds of different harms, and the inability of government that you're suggesting to reach out to these platforms and say, we want to give you information that you might not know about on this, and we want to give you our perspective on what harms that this is doing. And we want to be able to answer questions that you have.
Go away, government.
Because we really do think that it would be a good thing if you, on your own, chose to take this speech down.
And Your Honor, if those were the facts in this case, then I think it'd be a much harder case for me.
I don't know what your standard is. You just told me that was good enough for you. That was coercion.
No, Your Honor, because, in that circumstance, you have a platform who's reaching out, or the government reaching out just to identify what it views as the right state of the law, right state of facts. The government, this court has made clear for a while, since its plurality opinion in Alvarez, that if the government thinks there's false speech out there, the remedy for that is true speech. Nothing prohibits the government from going to that platform and saying, we've seen a lot of false information about election activity and COVID and vaccines and the like. Nothing prohibits the government from saying, here's a list of everything we say is true, that is true in our view, and you should amplify our speech. And anytime that false speech arises, you should put our post right there next to it saying, this is the government's view on this issue. The problem here, and this is, I think you see this in the summer of 2021, after the White House goes nuclear on the platforms, is that the platforms themselves reverse course on their own policies. And you see this in ROA 15322. This is one of in my view, one of the hottest docs in the JA, because you've got this email from Nick Clegg, who is, former Deputy Prime Minister of the UK. And after all of this pressure for months and months and months, he sends this email to Vivek Murthy, the Surgeon General, and he says, Dear Vivek, thanks for taking the time to meet. I wanted to make sure you saw the steps we took this past week to adjust policies on what we're removing, to take steps to further address the disinfo dozen. We've removed 39 profiles, pages, groups, Instagram accounts. We're continuing to make other accounts harder to find.
Slimy government.
This is an example of platforms moving beyond what their own policies require because they felt pressure to take more action and to censor more speech. And Your Honor, if that's not the clearest example of the government,
tell me where you have in the record that the 39 accounts that were taken out, that any of them related to any of the petitioners here?
Sure, Your Honor. So what I was
give me that site again.
What I was quoting to you right now is ROA 15322, and what that email from Nick Clegg mentions is the so-called disinformation dozen. This is a group of people that the government thought was responsible for the majority of so-called health misinformation on social media. Now, in paragraphs 5 and 6 of each of the supplemental declarations in the joint appendix, each of our individual plaintiffs specifically identifies the fact that they follow members of the so-called disinformation dozen. They repost their posts, they engage with their speech. And so when the government, or when the platforms here, in response to the pressure, are taking down contact and accounts related to those individuals called the disinformation dozen, that is necessarily impacting our plaintiffs' right to engage with their speech, to add their own comments.
Not that they've taken down any of their posts, but that they took down someone else's posts. That's what this is saying.
That's what I was quoting to you right now, Your Honor.
I'm not sure how that shows traceability or redressability.
In the same vein,
and I don't think we've ever dispensed standing on the basis of injury to another. Injury to you, but not to another.
So, Justice Sotomayor, let me give you Jill Hines one more time. Look at JA 793 to 794. This is the tweet it was a screenshot of a tweet that Mr. Fletcher mentioned. And this is censorship 4 times over, because this is a tweet in April 2023. It's on the eve of the preliminary injunction hearing. And what she says is, this Facebook post that I posted was taken down by Facebook. She got a warning for it as a violation of the community standards. What was that post? It was a screenshot of Robert F. Kennedy Jr., who was a member of the so-called disinformation dozen. What was the RFK tweet talking about? It was talking about Tucker Carlson, whom the administration was obsessed with. Look at JA 701 to 708.
I'm sorry. The RFK tweet, there's only a record of the White House asking Twitter to remove a tweet on, and not particularly this one from RFK. That doesn't help Hines's claim that the White House asked Facebook to remove anything.
It does, Your Honor, because, and this is a good example of the interrelationship between the various media platforms. You have cross-posting. So what happened in this example is Jill Hines took a screenshot of a tweet, and then she moved that over to Facebook and posted that as her own Facebook post. And so when she did that, she moved RFK's tweet, and I was going to describe what was in that tweet. He was talking about Tucker Carlson, that the White House specifically targeted.
Just
in
joining
the
us, this
appendix.
case is about
And that-
government
I have such a
and its
problem with
coercion
your
of
brief,
free
Counselor.
speech on the social media platforms.
You omit information that changes the context of some of your claims. You attribute things to people who it didn't happen to, at least in one of the defendants. It was her brother that something happened to, not her. I don't know what to make of all this, because you have a lot. I'm not sure how we get to prove direct injury in any way.
So
Liberal
Justice
justices
Sotomayor, let me
are
start by
just towing the
apologizing if
line.
any aspect of our brief was
Sad.
not as forthcoming as it should have been. I would take full responsibility for that. I apologize for that, Justice Sotomayor. What I would add to the second part of your question is I think Jill Hines is the best standing for our case in multiple ways. I think one of the ways you look at her standing is you look at JA 715 to 716. This is an email to Facebook where the government, the White House, specifically asks Facebook to not distribute so-called vaccine hesitancy content and also to target health groups that do that. So that's JA 715 to 716. Then you go down earlier in the JA to JA 631 to 632. This is Jill Hines' allegations. And what she says is 2 months later, so the email I just described to you from the White House was in May. 2 months later in July, and then a couple of months later in September, Jill Hines had 2 health groups in Louisiana that were blocked by Facebook. And I think this is one of the scariest examples in the record of what is at stake here, which is those groups were political action groups. Louisiana had a legislative session in progress. And what Jill Hines was trying to do is mobilize people to support certain bills and other legislative materials that were then pending in the state legislature. But because the government moved its pressure, put a thumb on the scales, a couple of months before, and then lo and behold, once Jill Hines tries to use the exact kinds of groups that the government targeted, she can't. They're pulled down. Her political organization is stymied. And that's, all over the record, and that's just one fraction of the kinds of harm that's at stake here.
So
Your Honor.
can I ask
That's your
you?
best. No, go ahead.
I want to go back to actually your interchange with Justice Kagan about the standards, because I have to confess it left me very confused. It sounded like you were articulating different standards depending on a different legal standard, depending on different factual circumstances. For example, when Justice Kagan gave you the hypothetical of pressure being placed on the New York Times or the Washington Post not to run a particular op-ed, it seemed like you backed off and said, well, significant encouragement wouldn't be enough there because the person who wrote the op-ed can go to another news outlet. You also made the point that this is just different because social media is such a concentrated industry, which is a point that Justice Gorsuch was asking Mr. Fletcher about. So can you clarify, did I misunderstand? Because it seems to me that as a matter of law, the same legal standard would have to apply across all of these areas.
I think that's right, Your Honor, and I apologize if I wasn't clear earlier. I guess the top line legal standard I would start with was this court's line at 635 in Norwood, which is the court can't do indirectly what it's constitutionally prohibited from doing directly. The second line in response to that is, well, what sorts of indirect mechanisms can the government use that would run afoul of that rule? I think one potential mechanism is coercion, another one's encouragement. This court also has used the term
Just
inducement.
plain vanilla encouragement, or does it have to be some kind of significant encouragement? Because encouragement would sweep in an awful lot.
I think that's right, Your Honor, and so let me give you 2 answers to that. The top line answer is, I'm a First Amendment purist, and so I would say even mild encouragement, but we don't need that to win in this case because we are so far afield from whatever that threshold is. So if you want to say substantial encouragement, like the Fifth Circuit said, and like Bloom said, absolutely, that's a standard that works. But I guess what I don't...
Well, let me just ask you then, let me give you a hypothetical. Let's say that you get doxxed, and so do numerous other members in Louisiana state government. You're doxxed, and somebody's posting online about how people should really rally and do something about this. People should rally and you should be harmed, okay? The FBI sees these posts and calls the social media outlet, like X, Facebook, whatever, and says, we really encourage you to take these down because these are significantly threatening and we see some people may be responding to them. That's a problem?
So my first question, Your Honor, is whether that would be protected speech, that those tweets would be protected
Okay,
speech under this court's precedent.
let's assume that everything that's said, I was trying to make it so that they
They are.
stop short of actually being illegal in and of themselves.
Your Honor, so I think, and as I say, I'm a purist on the First Amendment, so my answer would be,
So the FBI can't make, do you know how often the FBI makes those kinds of calls?
And that's why I have my backup answer, Your Honor, which is, if you think there needs to be more, the FBI absolutely can identify certain troubling situations like that for the platforms and let the platforms take action. I think the hypos are very important, but when you look at what's happening in this case, for example, with respect to the FBI, what they're doing is there's no emergency, nothing of the sort. They're just identifying
But that's
hundreds
just
of
kind of
accounts.
falling back on, well, this case is different, and so a different legal standard should apply. But, what we say in this case matters for other cases, too.
It does, Your Honor, and and I guess what I would say in response to that, and I'm very sensitive, obviously, given the facts of the hypo, to the outcome, but if what the FBI is doing is trying to persuade a speech intermediary to take down a private third-party speech, I mean, that is covered by the plain text of Norwood, and that's, an abridgment of speech, and
So I think that part of the reason why you might be running into all of these
Norwood's
difficulties
referring
with
to a
respect to the different
1973
factual
Supreme Court case about
circumstances is
textbooks
because,
and private schools,
you're not
the government.
focusing on the fact that
First
there
Amendment.
are times in which the government can,
In the 14th.
depending on the circumstances, encourage, perhaps even coerce, because they have a compelling interest in doing so. And so that's why I keep coming back to the actual underlying First Amendment issue, which we can isolate in this case and just talk about coercion. But I think that you have to admit that there are certain circumstances in which the government can provide information, encourage the platforms to take it down, tell them to take it down. I mean, what about the hypo of someone posting classified information? They say, it's my free speech right. I believe that I got access to this information and I want to post it. Are you suggesting that the government couldn't say to the platforms, we need to take that down?
No, Your Honor, because I think that would be a great example where strict scrutiny would cut in the government's favor.
All right, so what do we do then in a situation in which, I suppose in this case, we're asking, the government's point is we didn't coerce, and I appreciate, the debate about that. But you just seem to suggest that as a blanket matter, the government doesn't have the ability to, encourage or require this kind of censorship. And I don't know that that's the case.
So, Your Honor, I guess this goes to the bully pulpit as well. As I understand that the bully pulpit has never been used to target the object of suppressing a third-party speech. You can use it to coerce behavior, you can use it to coerce companies to take certain actions, but when the government is identifying a specific viewpoint and specific content that it wishes to wholly eliminate from public discourse, that's, I think, when the First Amendment problem arises. And so I guess I'm struggling to find an example in the court's cases or in history where the court or anybody else has said the government, by virtue of being the government, can use its power to pressure speech intermediaries to eliminate entire viewpoints and content from the public discourse. And I think, that's Your Honor.
Can I give you a hypothetical?
Sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Interesting.
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. This is obviously extremely terrible, and the public shouldn't tolerate this. The platforms, we see it's going on the platforms.
But they can't call the platforms and say, listen, we really think
It's
you should
wild.
be taking this down because look at the problems
This is
that
the
it's
hypo
causing.
they come up
If it's
with.
protected
It's like,
speech,
what
Your
if
Honor, then I think we get
we're
closer.
injecting
But,
people
look,
with
if you
poison,
think that
but we
that's-
want to continue
if
to
that's
inject
clearly
them
the
with
way you're asking the
poison?
question, I understand that the instinct
That's the hypo.
that may not be a First Amendment
And
issue.
people don't want to
I
be
guess what I'd
injected
fall
with
back on, Your
poison,
Honor, is
and they're
that at
speaking out
least
against it?
Where the government itself, there is no emergency like this. There's nothing.
Unreal.
No, my hypothetical is there is an emergency. My hypothetical is that there is an emergency.
Is someone
and I guess
pushing
I'm
them out
asking
the
you,
window,
in that
like in the
circumstance,
case of
can the government call
COVID?
the platforms and say, this information that you are putting up on your platform is creating a serious public health emergency. We are encouraging you to take it down.
Our hospitals
I
getting
was with you
thousands
right
of
into that
dollars
last
to push
comment, Your
people out
Honor.
the
I
window.
think they absolutely can call and say, this is a problem, it's going rampant on your platforms, but the moment that the government tries to use its ability as the government and its stature as the government to pressure them to take it down, that
We're
is
coming
when
up
you're
on an hour
interfering
here,
with
folks. I'm
third-party
going to
speech
leave the
rights. And
link
remember, the third-
right here. I just
ahead,
put it in the
finish
chat. I don't know if you can click on it, but just go to supremecourt.gov. Right there on the first page, you should be able to click on the calendar and listen to the oral arguments yourself. I'll be back for NRA versus VULA, which is another First Amendment argument against the government for essentially making banks and insurers debank the NRA. I'll be back for that later. If you haven't already, please subscribe. Remember, knowledge is
Your Honor,
power.
if the test is
Subscribe for
coercion
more.
and that's the test that this court applies, I think I might have a harder case saying that's coercion.